Sarah acts for a range of trading companies, charterers, owners, and banks in shipping and international trade disputes. And her main fields of experience include sales contracts, charter parties, bills of lading, letters of credit, and she has been very successful in numerous claims involving arbitration and litigation. She also advises on compliance and export control issues, focusing on US, EU, and Swiss sanctions, and teaches extensively on sanctions and international trade issues. And Daniel advises traders, ship owners, freight forwarders, insurers, and brokers on regulatory and compliance issues, including international trade sanctions, export controls, customs, and anti-corruption legislation. And he advises on all aspects of the EU and UK sanctions legislation, and he's also familiar with the application of US sanctions to non-US citizens. And further, he advises clients on disputes arising from charter parties, sale contracts, bills of lading, marine insurance, and logistics operations. And let me finish this, this very quick and rough introduction by saying that we're extremely happy that Sarah and Daniel are willing to share their expertise with us today, as the topic of sanctions is crucial for really anyone working in international trade in order to understand how sanctions work, how they might impact operations, and how these operational issues can hopefully be avoided. And with that being said, I'd like to pass you on to Daniel. Stage is yours.
Fantastic. Thank you very much indeed. Thank you, Fabian. Thank you to the network and the various chapters for kindly inviting us to talk to you. I'm calling from a slightly chilly London evening, but wonderful to see so many people. I'm looking forward to finally being able to get on a plane soon and hopefully see some of you in person. I recognise various names on the screen, and yes, it just reminds me how nice it will be when we're able to finally start seeing people in person. I'm going to try and make the technology work by sharing some slides that I just put together this afternoon, which hopefully you can now see. Forgive me, these were my speaking notes. They're not the most attractive of slides, but they will give you the meat and the bones without perhaps all the pictures. We've got about 45 minutes for Sarah and I to talk you through some of these issues. What we wanted to do was really cover sort of 6 overarching topics, generally relevant to sanctions issues, and then focus in a little bit more detail towards the second half of the session on 4 specific regimes. I'm going to briefly touch on where we are with Afghanistan, look at Iran, look at Russia, and Sarah's going to do a little bit more discussion around Russia, and also look at Belarus. We should at the end have plenty of time for questions. I'm very happy to take questions as we go through as well. If people want to put their questions in the chat, we can pick them up as we go. So if my slides move on, there we go. In terms of the general points then, what I thought it was worth covering, and as both Claudio and Fabian have said, these are hugely topical issues at the moment. My personal sanctions journey started in 2010. At that point, more years ago than I care to remember, the real focus at that stage was on Iran, of course, and the developing sanctions landscape, whether it's with respect to Iran or Cote d'Ivoire, Libya, Russia, Belarus, and other jurisdictions, has kept me and my little team very busy in that period. As I say, there are some specifics to come on to, but generally I thought it was worth touching on these are general questions in terms of what sanctions regimes are applicable. So in other words, where do you need to look for the rules that will govern what you can do and cannot do? Then thinking about the specific sorts of restrictions that are relevant to the industry. People will be familiar with a number of these issues, but really thinking about what sort of restrictions apply. Then we have a little look around enforcement. Clearly with any of these compliance topics, one of the key questions always from business sectors and from commercial people is, well, yes, those are all the rules, but does anyone really care? And sanctions is very much an area in which people do care, and which we have seen significant sanctions enforcement. Having set that scene in terms of where the rules come from, what the rules are, and why they matter, I wanted to look in a little bit of detail as to specifically what issues are we concerned with respect to shipping. And we'll talk about it generally, but of course, and as we'll come on to when we think about what might happen next if the situation escalates on the Ukrainian border, these sorts of operational issues are the sorts of things that people are going to be grappling with if we see new sanctions imposed on Russia. So worth understanding the broad framework. There are lots of rules. There is guidance available. We've seen governments publish guidance, some of which is more helpful than others. But I wanted just to direct you to some of the pieces of guidance that we have seen. And then thinking a little bit around practical stuff. What do people actually do to manage these risks? It's all very well lawyers talking about all these terrible things that you have to do, but what are the practical suggestions to deal with them? So just starting with this question of which sanctions regimes impact on the industry. Clearly, national rules will apply wherever you're based. So if you find yourself, if you're in Zurich, if you're in Hamburg, if you're in Mumbai, then clearly local rules will apply. And people will be familiar with the operation of those local rules, whether, as I say, they're Swiss rules or German rules. But importantly, of course, with it being an international industry, those local rules are not the only sets of rules that will apply. We're concerned, in addition with local rules, with various supranational and transnational rules. People's focus understandably tends to be on the US piece, and US jurisdiction will apply where we have a connection with the US. Now that may be payment of hire under a charter and a US clearing bank being involved in processing that payment. And we may have US jurisdiction apply because we have a US national involved. And certainly in the case of some of the US restrictions, they will also apply to non-US entities where they're owned or controlled by US persons. But really important to understand that scope for those US rules to apply because of a connection to the US. But in addition, US rules may also apply where there's no connection to the US. So what sanctions lawyers will tend to talk about as being secondary sanctions or extraterritorial measures. These are restrictions that apply even if there's no US connection. Now, theoretically, and we can get bogged down in the jurisprudence, but technically these are not offenses. These are not extraterritorial rules. Essentially what happens instead is that the US really gives commercial organizations a choice. Either they follow those US extraterritorial restrictions, in which case they are free to continue trading with the US, or alternatively they choose not to do so, and then there are specific measures that the US can impose in terms of denying access to US foreign exchange, denying access to US government contracts, these sorts of restrictions. So as I say, very much a question, and we've seen this with Iran, of being forced to pick and choose either to support the Iranian economy or the US, but not being able to do both. And in the shipping sector, we've seen this very much come into focus. So we had classification societies and others who were essentially told, you can continue providing services to the US fleet, or you can provide those services to the Iranian fleet, but you cannot do both, and directly applicable to the industry. In addition to those rules will apply further from the EU or other jurisdictions because of other connections, because of other jurisdictional nexus. So it may be that if you have no other connection to the EU, EU rules are going to apply because your insurers are based in the EU, or you may have operations in the EU. Likewise with the UK. Those restrictions will apply, but really by reason of jurisdiction, nationality of individuals, incorporation of entities. So much for the sources of the rules. In terms of the specific restrictions which apply, often I talk about sanctions programs as being a bit like a menu in a restaurant. And by that, what I mean is that if you look across the whole range of different sanctions programs that are in place, and I'm thinking about it predominantly from a EU and UK perspective, but if you look at all of them, clearly it's not the case that sanctions that are in place today against Russia are the same as the sanctions in place against, say, Egypt. The remit and the range of different restrictions that are in play are very different. But nonetheless, if you look across all the EU sanctions programs and UK sanctions programs and other jurisdictions, what you see is the same restrictions are imposed under all of those restrictions. So if you start with the most straightforward and the narrowest set of restrictions, they will contain an asset freeze, and that asset freeze is in place across all of the different sanctions programs. And then what tends to happen is that politicians and diplomats will choose other options from the menu of restrictions and impose those, either because they feel that those types of restrictions will be particularly effective in achieving the objectives of the sanctions, or alternatively, what we see and have seen in the past is that if an initial round of sanctions are imposed and they're not effective to achieve the objective, or alternatively there isn't a change in behavior, then by having access to this menu of different restrictions that can be imposed, politicians are given a relatively straightforward way to continue to escalate the pressure. They're able to signal to the jurisdiction that's being targeted, and indeed to other jurisdictions, that they are taking the situation seriously because they keep on imposing more measures. So as I say, very many common features across all the programs. And I spent a bit of time yesterday and this morning thinking about what we might see if it comes to an escalation of the measures against Russia. And essentially, from my perspective, and we'll touch on this later, but there isn't very much new in the field of sanctions. Often the same sorts of restrictions are imposed, but they may have a broader reach. So let me talk about these 4 types of restrictions and explain what I mean by them, and then we can think about how it applies in context. So the asset freeze, as I say, is at the core of all of the different sanctions programs. Essentially, the way the sanctions, the asset freeze operates, and it's different across different sanctions regimes, but only really as a matter of detail, is that particular individuals and entities, either in the country which is the subject of the sanctions, or in other jurisdictions where there are links with the sanctioned country, or increasingly because they've been identified for engaging in particular behavior, whether it's corruption or human rights abuses. But in whatever the reason for their identification and their designation, those individuals and entities appear on a sanctions list. And these sanctions lists are publicly available. You can go to the SECO website to see the Swiss list. Likewise, HMT in the UK publishes the UK list. There's an EU list and a US list. So these are published lists of individuals and entities that are subject to that restriction. The restriction has 2 aspects, and really there's 2 sides of the same coin. The first aspect is that all of their funds and economic resources, so anything they have really of economic value that is within the jurisdiction of the sanctioning authority, is frozen. So if I'm added to a UK sanctions list, any money I hold in a UK bank account, shares I have, other valuable resources is frozen, and I cannot deal with my own assets. But substantially more significant and more important, particularly from our perspective, is the flip side of the restriction. Because not only are my funds frozen, but it's also prohibited for individuals and entities who are subject to these legal restrictions to make funds or economic resources available to me, whether directly or indirectly, or for my benefit. So not only is everything that I hold frozen, but it's also prohibited for other people to provide me with things of value. So I'm essentially excluded from international trade, commercial activity, because all of my ability to access funds and to use funds is frozen. So that's really the asset freeze. And people sometimes talk about it as a prohibited persons list, and that's not a bad way to think about it. These are the people you cannot deal with. The trade restrictions are different. In that the trade restrictions, what I mean by that is that they are prohibitions on dealing in particular goods and services.
Can I ask a question on 3? When we say they are frozen, it doesn't mean that they're being confiscated, but for a certain period of time I cannot touch them, but it's not that they take it away from the individual, right?
You're right, Vanessa, exactly. So if I say my money is held in Barclays Bank, rather than Barclays taking my funds and transferring it to the UK government and it being a sort of forfeiture type remedy, instead what will happen is that they will impose restrictions on that account, and the funds remain held in that account, but I'm not able to access them. And that's an important point because that's consistent with the fact that sanctions are intended not to be a permanent measure. So theoretically, what should happen is at some point in the future, that restriction should be lifted and I should have access to my funds again. Sorry, I cut you off.
But on the other hand, for example, a bank can be penalized with a fine if they violate sanctions. It's not the same as an individual, right?
You're right. So on those of banking enforcement, so the two are structurally different. If I am a sanctioned person, then I've been identified as someone whose funds should be frozen, and those are then held in that position. Where we've seen the enforcement against banks is been because because they've breached restrictions that are then in place. So it's almost a secondary issue. So they knew that they shouldn't be dealing with, say, Iranian funds or Cuban funds, and they violated those restrictions, and therefore the penalty they pay is for that violation. So it's not the case that the bank has been identified as a sanctions target, rather it's breached the restrictions. So someone like BNP Paribas entered a settlement, $8.9 billion, to compromise their sanctions liability. But that was because they processed payments on behalf of Iranian and Cuban and other sanctioned interests.
Thank you.
Then on the trade restrictions, really I divide those, they encompass both import and export restrictions. So if we take Iran as an example, there are restrictions on exports from Iran, but also on the supply of goods to Iran. But perhaps more significant in terms of a distinction, there are certain commodities that are restricted, certain goods that are restricted because of what they are. So there may be restrictions on nuclear weapons or chemical weapons or equipment for internal repression, things like that. The sorts of things that a ship owner would see on a manifest and would understand that they would be controlled essentially wherever they're being transferred, because there's something about the nature of the product that is not purely commercial. And those are relatively straightforward to process. As a shipping line, you may well have restrictions in the charter as to the cargoes you will carry. So you may say no military goods, those sorts of restrictions. Where things are more difficult with the trade restrictions is they also target purely commercial goods. And they target commercial goods that have been identified and made the subject of the sanctions measures because they have an economic value to the regime that is the target of the sanctions. So if, as a diplomat, you want to cause a change in behavior in a particular regime, and you believe that that regime is engaging in a certain type of activity which you want to stop, and you believe that it's being funded by exports of particular commodities from that country, and that's the source of foreign income that then funds that regime, then you would tackle those measures. So whether it is exports of oil and gas from oil-producing countries, whether in the case of historic sanctions in place against Burma and Myanmar, and there was a focus there on exports of jade, of timber. We've seen restrictions on exports of gold and other precious materials. But the point I just want to make there is that those commodities and goods have been selected not because of the same inherent vice, we might say, that leads to controls on military goods and on dual-use goods, but rather because of their economic value. Which of course creates a particular challenge because it's more difficult to contract on the basis you won't carry them, because you might well be prepared to carry them for other jurisdictions, and also it can make it more difficult to identify the sorts of products that might be controlled. And I'm not going to steal Sarah's thunder when it comes to Belarus, but certainly in the case of Belarus, we've seen these sorts of restrictions and had to map out the issues. I'll leave that to Sarah. So those are the trade restrictions. So if the asset freeze are people you can't deal with, the trade restrictions are goods and services you can't. The sectoral sanctions are a newer creation, probably dating back to 2014 with the Russia measures. And to some extent, they're a bit of a hybrid between the asset freeze and the trade restrictions. What we've seen in the case of current restrictions against Russia are really measures that are targeted at particular Russian entities and their ability to access European, Swiss, US debt and capital markets. So what you have is, in the same way that under the asset freeze, you have a list of individuals and entities you cannot deal with, likewise under the sectoral sanctions, there is a similar list of particular entities. And it includes the likes of VTB Bank, Sberbank on the financial side, Transneft, Rosneft on the energy side, Kalashnikov and others. But importantly, the appearance of those organizations on that list has a different consequence to the asset freeze. Where entities appear on the asset freeze, essentially it's prohibited to deal with them. And it doesn't matter what the activity is, anything of any commercial complexion will be prohibited. by contrast with the sectoral sanctions, where the restrictions are in place, it's important to understand that yes, those entities appear on sanctions lists, but it's not the case that all activity with them is prohibited. It's only certain things that is prohibited. And then final set of restrictions I thought was worth touching on. What we have seen across a range of different sanctions programs, thinking of the North Korea sanctions, Iran sanctions historically, and some of the other sanctions programs, are measures that are specifically targeted at those jurisdictions' fleet. So there may be restrictions on supplying crewing services to vessels, or on flagging or registering vessels, or on providing other services to those vessels. So there, North Korean flagged vessels and Iranian flagged vessels in particular, there are restrictions on the services that those organizations that are ancillary to the shipping industry are able to provide to those particular vessels. But as I said at the beginning, a range of different measures that are in place. I wanted to touch briefly on enforcement. Thanasis's helpful question has alluded to some of the enforcement.
Well, Daniel, I have one question. Sarah speaking here from Hamburg. Where do the territorial restrictions fall under? If I remember correctly, you have certain territorial restrictions regarding Russia that only oil and gas from certain region is prohibited to trade with.
Yes, if we go back to so let's go back a slide. So Sarah, you're absolutely right. So where we are currently in terms of Russia is that in that bucket of trade restrictions, as well as restrictions on some exports from Russia, the measures you're talking about are primarily directed at restrictions on the supply of equipment to Russia. So currently at an EU level and indeed at a UK level, there's a requirement that the supply of certain really drilling equipment and other oil and gas related equipment that is being supplied to Russia has to be authorized in advance. And that framework for authorization specifically excludes certain type of Russian energy projects. So it excludes deep water, Arctic and shale projects. And I think that's perhaps what you have in mind.
Yeah.
Okay. So we're not at the point currently of prohibiting the import of oil in particular that's generated from those fields, but the prohibition is on the supply of equipment to those fields. And therefore there have been discussions in the past around what is meant by Arctic and what is meant by deep water, how deep is deep water. But really that's how those fit in, is that there's a restriction on the supply of the equipment, but the equipment will not be permitted if it's for projects that are of those particular types.
Okay.
And it covers less of things. Good. Let me find my cursor on the slides again. Right. So as I said at the beginning, and before I started, one of the things that perhaps makes sanctions compliance, it's not easier to deal with, at least easier to focus attention on, is it is an area in which we've seen significant enforcement. The conversation that Thanasis and I were having around bank enforcement is slightly different to the enforcement I want to talk about, but let's talk about that enforcement first, and we'll come back to this enforcement. What we've seen historically is that the US in particular has been very aggressive in enforcing sanctions violations. And if you go back, say, more than 2 years ago, enforcement was against predominantly financial institutions and predominantly non-US financial institutions that had been involved in processing payments, usually where there was a US dollar element, in support of or for the benefit of the sanctions jurisdiction. And we saw fines that ran, as I said, BNP Paribas, the settlement of $8.9 billion. There were numerous banking violations, $600 million, a couple of Italian banks. We've seen German banks, British banks, Russian, Japanese banks enforced against. What I think has happened over the past couple of years is that previous pattern of enforcement against banks had the desired effect from a regulator perspective, in that every bank globally is terrified of sanctions issues. and therefore those banks are ensuring that their customers are not exposing those banks, and the banks are choosing to block payments, in other words, to not process them, or indeed to reject payments where they have any concern around sanctions issues. And therefore, where I think we've ended up is that now, if you look at the pattern of US enforcement over the past couple of years, it's far less focused on banks and much more on commercial organizations. In each of those cases, though, all of those enforcements, almost without exception, have been the outcome of settlement agreements that banks and others have entered into with US authorities, whether it's OFAC, who are part of the Treasury Department, or the Department of Justice, the DOJ, or others, to settle their sanctions liability. But the cases that I want to talk about are slightly different, because these are all cases where, rather than a financial penalty being imposed, what we've seen impacting on the industry are more aggressive enforcement actions, enforcement that has a greater consequence. So in the case of each of those 6 vessels that I put on the slide, those vessels were all, for a short period of time, included on the US SDN, or Specially Designated Nationals list. In other words, each of these vessels was subject to what the US would call blocking measures and what we would call an asset freeze. And therefore, in each of those cases, rather than the owners of those vessels paying a financial penalty to the US authorities for violating sanctions, instead the vessels and indeed the ship-owning companies in question were added onto sanctions lists. Now, I say that has a much more dramatic effect because the consequence of that is that third parties, whether it is SPNI, whether it is port operators, whether it's other the new charters at the time the measures were adopted, and various others, were then unable to deal with these vessels. So in each case, and this is all enforcement in June in 2020, we're talking about vessels that carried Venezuelan oil in February or March of 2020. Now, I'm not going to get into the detail of exactly what happened and why it happened and whether it should have happened, because really the important point that I wanted to make here really is that in each of these cases, sorry, that's not quite fair. In some of these cases, I know that by the time the enforcement happened, the vessels were then on charter to new charterers, were either laden with cargo or were waiting outside ports. And therefore the consequence, from my perspective in dealing with it operationally, was much more significant for these vessels and their owners than a mere financial penalty, because it meant they couldn't trade the vessels. As I say, each of these vessels is no longer on a sanctions list. So they're on the list for that short period of time. And they were listed by OFAC, the US authority, and then they were delisted following engagement by those owners with OFAC and essentially reassurances that there wouldn't be a violation in the future. So that was the history there. I've put on the bottom of the slide, these are instances in which individual masters of vessels, captains, were themselves added to a sanctions list. Now, it's not quite as chilling as it first looks, because in each of these cases, and you wouldn't guess it from the names of the vessels, these are all Iranian vessels with Iranian masters. And therefore, to some extent, it seems to me that it's perhaps less significant for those individuals that they're on a US sanctions list, because their level of engagement with the US is very limited, and they are Iranian nationals operating on Iranian vessels.
Actually, the majority of those vessels look Greek to me.
Sorry, Thanasis, I mean not the Athens Voyager down to the Delos Voyager. I mean the Clavel, the Petunia, and others.
Oh, okay.
Okay, yeah. So you're absolutely right. The top 6 are all Greek vessels, are all Greek vessels.
No, I would like to raise one point, which maybe at the end you would like to answer. I guess avoiding sanctions and protecting yourself from sanctions is relatively easy. You can read, you can follow. It's pretty much everybody knows what is on sanctions. I think that the most difficult part is if you're having a trade which is clear, but while you're trading it turns sanctioned. I think this is the most, let's say, for example, I trade with Venezuela, January 2020, and I'm on a time charter or something, and then US imposes secondary sanctions while I'm on charter, and then the vessel is kicked out of the SPNI, the insurance, your bank doesn't accept payments anymore. This is the most tricky part, and what steps you can take to rectify that, since you have done all your proper due diligence up to that point. And where, I guess, if you have any advice, it would be very helpful.
So you sort of anticipate one of the points on my next slide. So let's jump ahead in terms of the sort of operational issues.
Sorry, I don't want to.
No, that's fine. No, my quick point on the previous slide with the Clavel and others is Iranian masters, Iranian vessels, but I think it did create a bit of concern that masters might find themselves in a position where they're getting orders from shoreside to engage in particular voyages. And then I see to some extent, this is your point as well, is that what happens if the master is pursuing a voyage which at the commencement was a lawful voyage, and then things change, this sort of action leaves the master in a very difficult position in that he knows what those at the shoreside want him to do, which is to continue with the lucrative trade. But this sort of creates the spectre that actually that individual might face a degree of personal liability for pursuing the voyage. But let's come on to what happens and what might arise. Oops, sorry, I've gone too far. Then I said, do you mind if I run through these and then I'll come back to the change position that you mentioned? Is that okay? Thank you. Okay, so and Thanassis is right. These are issues and risks that are well known, but are worth enumerating. So concerns around the fact that those we deal with might be sanctioned entities, whether it's our charterers, whether it's port operators, it might be banks that are the beneficiaries of bills of lading that the master is issuing, it might be insurers, all sorts of different entities that we are dealing with. Likewise, concerns around sanctioned equipment or services, and predominantly what I mean, of course, is the situation in which owners agree to carry cargo in reliance on information provided by charterers that the trade is lawful, and actually it transpires that it's not. In each of those cases, clearly the key is around operational due diligence, KYC, and in understanding who we're dealing with. The challenge when it comes to sanctioned counterparties is often around understanding who stands behind our immediate counterparty and being in a position to identify beneficial owners, shareholders, and ensure that we're not dealing indirectly with a sanctioned person. On the cargo side, sometimes resolved, so we've helped clients with screening cargoes, particularly on the liner side, but also resolved by obtaining warranties and doing DD in terms of what our charterers are able to, what we're allowing charterers to carry. But yeah, I will leave Sarah to talk about issues around origin of cargoes, which is particularly challenging. Another significant issue for the industry is understanding where there is a US connection, and therefore US primary sanctions will apply because of that connection. So do we have US nationals? And we've helped clients to put in place what are called recusal measures so that our US nationals who carry, of course, with them their US jurisdiction are not involved. Similarly, if anyone is physically present in the US, even if they're not a US national, they are subject to US jurisdiction while they're in the US. So I've certainly been in the position of having to terminate phone calls while I've been in the US on business trips, because at that point I was a US person and I could tell from the tone of the conversation that I was having on the phone with someone that if I continued the call, I would be in breach of US rules, and therefore I had to stop that conversation. Likewise, around US Nexus, there are continuing discussions around whether the US dollar, which undoubtedly gives rise to US Nexus, but whether we are seeing trades moving to a non-dollarized basis because of these concerns. So we're not at a point at which the US is suddenly going to stop asserting jurisdiction in order to protect the dollar as the international currency of trade. I think the US is quite happy to continue asserting jurisdiction through the dollar, but whether in 20 years' time we'll still be there, who knows? So some of these other points are more, well, I'll gloss over in terms of issues with insurance, in terms of banking. Really the point being that whatever view we take as a ship owner or as an operator in terms of our risk appetite, in terms of our sanctions exposure, clearly we are reliant on our insurers, whether it's SPNI or Hull, their reinsurers, and also on the availability of banking and the availability of credit. And those who've dealt with these issues will know that whether it's SPNI rules, whether it's insurance cover, whether it's banking covenants, it is invariably the case that they include a sanctions clause, because banks and insurers want to protect themselves. So a couple of challenges, and Thanassis has raised the first one kindly, so we'll tackle it. So the concern here, of course, and to some extent, both of these challenges are the same. So dealing with a change in the sanctions mid-contract and dealing with an incident. In each case, I'm assuming that we have done full KYC, full DD at the commencement. And there is that initial period in which, if our operational team are providing information to compliance and legal early enough, we have the luxury of time and we can think about what we're doing, we can run our checks, we can seek more information. But things become much more squeaky when it comes to sanctions change mid-contract, or indeed an incident potentially involving liability to a third party, because everything is happening in a rush. And I think there are a number of different things that happen, and I am finally going to answer Thanassis' question. I'm going to just dance around it. So sometimes what we have is there's a change in the legal position, and therefore the legal position changes mid-contract. And that change in the legal position takes two forms broadly. Either our counterparty who wasn't previously sanctioned becomes sanctioned, or alternatively, the trade that we engage in that wasn't previously sanctioned becomes sanctioned. Let's talk about those scenarios first, and then we'll come back to the Venezuela case, because to some extent, what was happening with Venezuela back in 2020 is a bit of a special case. Where the status of a counterparty changes and they become added to a sanctions list, that will have immediate effect. And therefore, a counterparty that it was lawful for you to deal with on day 1 may now be unlawful for you to deal with on day 20. And therefore, it's important to continue ongoing monitoring. Where we are essentially left is that, to some extent, under some of the sanctions programs, there is scope either to apply for a license in order to wind down an existing contractual position, whether in terms of making or receiving payments, or there may be provision within the rules that you don't need to seek a license and it's just generally permitted. But certainly, and this will be a live issue if we see more measures imposed against Russia, one of the questions will be that if a counterparty becomes sanctioned, is there an ability under the sanctions legislation to continue performing? Alternatively, and if there is not, this is when you're going to be looking at the sanctions clause in the contract to see whether the clause in the contract gives suspension rights. So you'd be looking to suspend performance, so either not delivering the cargo or not making payments, and or potentially termination rights, depending on how it's crafted. And I think for that change in the sanctions position of a counterparty, really that's the key, is ensuring that the sanctions clause deals with the situation properly, and that you can manage that risk.
Can I bring just a practical issue to that? It's much easier if you're ballast, but if you are loaded, it makes it much more difficult.
Yes.
You mentioned that you would need to apply for an extension, but practically, let's say suddenly U.S. sanctions apply to your counterparty or whatever, you have to contact OFAC for that, or practically who do you apply to?
So if you needed a specific license, so what we've seen in the past, so whether we look at Venezuela, or some of the other sanctions programs. Generally speaking, recently, at the same time that OFAC has imposed measures, they have issued general licenses, so licenses that are available to everyone, that allow wind down of pre-existing contracts. And they tend to be time limited, but they will allow, wind down of those existing contracts. It doesn't allow you to enter into a new contract, but you can wind down the existing one. So in that situation, no, you don't need to make an application. But if you need to apply for a license to authorize something that would otherwise be a breach of US rules, you would need to apply to OFAC. And I can anticipate your next question, which is how long does it take? How much does it cost? And what are my chances? Classic questions. And the answer is it depends, and don't hold your breath a lot, and cross your fingers and hope, because it does take a long time. And what we've seen dealing with OFAC is we've had applications that we've made that have taken months to resolve, because all of this is bound up in politics and diplomacy as much as it is a legal question.
Just to jump in there, Dan, very interesting point on the timing. We once applied for a release of funds from OFAC. Those funds were finally released. In other words, OFAC agreed that the basis of the release of fee was towards 10 million, quite a large amount of money. It took 4 years for them to rush back the answer to us. Now, by contrast, we are frequently in touch with the Swiss regulator SICO, and they will generally reply within weeks or a month, and short queries often within days, often quite significant queries with significant consequences. That, of course, is because Switzerland is servicing a smaller market in terms of these sanctions queries because of OFAC's secondary sanctions regime. But it certainly is a very different regime when you look at sanctions across the globe. Thank you, and sorry to interrupt, Dan.
No, thank you. No, I'm glad you did. Thank you. Yeah. So that was the risk if the counterparty becomes sanctioned. If the cargo becomes sanctioned, then again, ordinarily, we would see a grandfathering provision, as it tends to be known, which allows wind down of existing measures. I think, and I don't necessarily want to get into a huge amount of detail, but the issue with those Venezuela trades, and in particular with those vessels, is that, and you have to remember these were the days of the Trump administration, things were changing rapidly. And I think one of the issues with those vessels was that what happened there was not necessarily a change in the legal position, but people had been relying on guidance and indications from the Treasury Department and the State Department as to what was permitted and what wasn't. And what changed, from my perspective, when we looked at it in terms of the US position, was not a legal change, but rather a change in the attitude of those agencies. And I think the reason that matters is that takes you out of the legal framework of a change in the legal position accompanied by these sorts of grandfathering provisions. And therefore, I think the biggest challenge comes not from a change in the legal position, but rather than a change in those sorts of enforcement attitudes or attitudes taken to particular types of activity. I think where we come back to with all of this is really, in terms of practical suggestions, 2 or 3 things. I think it's around understanding the nature of the dealings with the sanctioned country. So exactly who are we dealing with? What is the trade? It's around having proper contractual protection in place. And certainly Sarah and I do a lot of work drafting contractual warranties, representations, indemnities, and other provisions that are intended to address that risk. And then I think the third thing is having the connections and the contacts with regulators and others to understand what's coming down the track. And I think one of the things that I would probably say, to the credit of US agencies and others, is that I think they understand the industry better now than they did in 2010. I remember we hosted a roundtable in the office for the State Department in 2010 around CISADA, and it was slightly terrifying the extent to which they were willing to penalize the industry but didn't understand how it operated. And then by contrast, I was at a US Embassy event just before the guidance I'm about to come on and talk about, in I think February of 20, and they were much more knowledgeable. But as I say, I think those are the sort of the main points. Sarah, any thoughts from you in terms of other things that people should do to manage those risks?
No, all very, very relevant. And I do agree with you, Dan, in terms of the change in approach and attitude. An incredibly sophisticated industry. We see, I'm thinking particularly here of the sophistication that is involved in the timings in the sectoral sanction identification list regulations. That is to say, the time limits which are imposed on new debt for that special Russian list of banks, which we're not dealing with today, but it really, it strikes me that has got incredibly sophisticated over the past half decade.
Yeah, very good point. Thank you. I'm going to touch briefly on another challenge, which is around deceptive practices, then look at guidance, and then touch quickly on where we are, Afghanistan, Iran, Russia, and then finally yield and give Sarah some airtime rather than you all having to listen to me go on and on. One of the challenges the industry faces, and I think it's much as both Sarah and I, as we talked about, have seen a development in the level of sophistication within the regulators and their understanding of the industry, I think it's been coupled with an increasing focus on the industry, and a recognition that the sorts of activities that are the target of the sanctions involve the maritime industry, and attempt to impose greater obligations on the industry. I've got things slightly back to front in terms of sequence, but let me just jump forward a slide. What we've seen is guidance from the US and the UK in particular, but also other regulators directed at the industry. So in May 2020, there's joint guidance from the US Treasury Department, State Department, and Coast Guard directed at the maritime industry. And likewise in July 2020, we saw the same thing from OFAC, which is the UK regulator. One of the things I think is interesting about the OFAC guidance are the deceptive practices that they identify, which are on the slide there. One of the things the US focuses on is perhaps a misplaced belief that there are silver bullets out there, and that if the industry did a little bit more of some things, sanctions would be eradicated, sanctions breaches rather would be eradicated. Now, kind of veering into personal opinion as whether they're right. I'm going to keep out of that, because otherwise I'll be on my soapbox and you'll never hear the end of me. But these are some of the things that they would like to see change. So there's a real focus from the US side on AIS. There's a real, I think, lack of understanding that there are legitimate and non-sanctions related reasons why vessel AIS data might not be available. But certainly it was clear, talking to the Treasury and state officials in February of 20 before the guidance came out, that they believed that AIS was the silver bullet, and that if vessels could just keep the AIS on all the time, there would be no issues. And I think what we've seen are switch off clauses published by BIMCO. We've seen various software companies using more and more sophisticated tracking, whether it's satellite tracking, other sources of data. And I think that pattern is set to continue. Vessels being monitored, but also I think increasingly sophisticated spoofing and other activities by vessels that are evading sanctions to conceal their location, because currently that's a real focus, is on tracking vessels. Issues around STS transfers are also very much a live issue, and then the usual industry issues around flag hopping, around complex ownership chains and management. For those who read Lloyd's List, there is a regular feature in there, and Michelle Bochum-Weiss, the journalist, someone I know very well, writing about subterfuge fleets, about vessels which are concealing ownership or are moving from flag to flag because they are engaged in sanctions trade. Michelle's focus is very much on Venezuela and Iran. but she's a sort of regular writer on the topic. But those are areas of focus. I'm going to skip most of this slide because we've talked about already really in terms of practical measures. Talked about DD, we've talked about sanctions clauses. A sort of plea, I suppose, on the sort of training and awareness side, events like this one are phenomenally useful, and Sarah and I are always very happy to talk to people and sort of highlight the issues. But I think there is a sort of increasing focus. I've seen it in US enforcement as well, that the absence of training and the absence of internal policies is beginning to become an aggravating factor when it comes to assessing penalties and a real sort of expectation. I put in there dialogue and timing. Really what I mean is dialogue with insurers and with banks. From my perspective, one of the things that if I had a silver bullet and if I could change things, I see quite a lot of duplication and repetition that will have a voyage. Owners want to be sure there's no sanctions violation. Insurers want to be satisfied. The bank wants to be satisfied, as do charters and everyone else down the chain. And I think the more we can have an open dialogue with banks and others about the sort of training activities, potentially the more scope there is to reduce that overlap, that duplication. Forgive me, I'm going to accelerate through because I just want to make sure that Sarah gets time to do her piece, and forgive me for going on a bit. This map just really sets out where we see the current risks to commercial organizations associated with sanctions. It might be because we are seeing rapid change on the sanctions side. It might be because the sanctions that are in place target lots of commercial entities that you might be dealing with. They target port operators, banks, insurers. Or it might be because we see a divergence between the US position and the EU and the Swiss position, and therefore additional compliance challenges. Really happy to share these slides afterwards, so I won't go through them in detail, but mapping out some of the current issues with Russia, and then I've got further slides talking about where we are on Iran and Venezuela, I think. I'm going to spend 2 minutes not talking to the slides, but I think I'm going to focus on Russia, and then I'll hand over to Sarah, because it seems to me that in terms of live issues, the issue with Afghanistan is relatively static. There are sanctions in place against the Taliban, but one of the key questions in any dealings with Afghanistan is in understanding the links that commercial entities have to Afghanistan, to the Taliban, sorry. I would say the live issue with Iran is, will we see a resuscitation or a reanimation of the Iran deal and further sanctions relief? But I think in terms of the key issue at the moment, Russia very much is it. We wrote a piece this morning, and Sarah and I together, around what might happen next with respect to Russia. Clearly, there's a lot of uncertainty. There's a lot of uncertainty as to what will happen on the ground. There's uncertainty as to the measures that might be imposed. But certainly from our perspective, the things that we would be saying to people to do now are around understanding the extent of exposure to Russia, whether that's Russian counterparties, Russian origin goods, those sorts of issues. Understanding who Russian counterparties are. I think if we see more measures, we will see further individuals and entities added to sanctions lists. And therefore, I think doing further DD now to identify those individuals and entities that sit behind Russian counterparties would be a hugely useful thing to do. I think to Thanasis's question around things changing, having done that contract review now to understand where we might be in the event of a sanctions change is going to be hugely valuable. And where possible, because clearly there will be cases in which we're not yet at a point where we've made final decisions, but really thinking about alternative methods of performance and what can be done in the event of a change. I think there's also an important issue around identifying the risks that you might face if there are Russian countermeasures, because I think it's clear that if we see more sanctions imposed against Russia, we can expect to see Russian restrictions imposed as well in a sort of tit for tat. With apologies for skimming through that last little bit, as I say, I think sort of focus on Russia is probably key for the moment. Really happy to talk to people offline in terms of issues around Afghanistan, around Iran, and elsewhere. But with that, I'm going to stop sharing and hand the floor to Sarah. So thank you very much, everyone, for your attention.
Brilliant. Thank you so much, Dan, for that very concise and clear presentation on what is almost an around the world tour, which we of course annually do. Interesting to see again that slide setting out the global sanctions risk that you have just discussed. And I am going to take us quite briefly actually through the EU Belarusian sanctions, just as an example of how an analysis should work, bringing together a lot of the pieces that Dan has highlighted. So we are looking at a set of EU sanctions that were handed down and really peaked in terms of what we saw coming through our practice in June of last year. And there were two different sorts of key sanctions that were that were issued by the EU. It was actually EU Council Regulation 765. The first was the classic listed entity, so a sanctioned entity, and some key Russian oligarchs and entities were added as listed persons, listed companies to Annex 1. And then there was this new round of sectoral sanctions, and they specifically targeted Belarusian petroleum products, potash, financial services, technology, software, dual-use goods and technology, tobacco, and insurance. Now, one of the interesting features of the specific potash sanctions, which I just wanted to highlight in case some of you had not picked up on this, is that they prohibited potash with more than 62% or less than 40% potassium content by weight, but not the range between those two markers. So just an interesting one there. The other point to note in relation to those sanctions is that the prohibitions were all actually without prejudice to contracts concluded before 25 June 2021. What that really means is that the prohibitions were effectively allowing contracts concluded pre-25 June to continue. Now there, of course, there's going to be a debate about whether those contracts would include term contracts. And the devil is in the detail when it comes to that analysis. Clearly a spot contract pre-June is going to come into that effectively license, which was a permitting license. The key issue there was really, which we were heavily involved in, was whether a listed person, and here we're talking about those very high profile Russian oligarchs who were listed by the EU and then in a round of sanctions also listed by the UK and by Switzerland, whether or not that listed person owns or controls subsidiaries. And the interesting thing under the EU rules in considering the test for ownership and control is that it's actually different from that, what is generally referred to by US lawyers as that bright white line, the 50% rule. It's a 50% test under the OFAC rules for ownership, but it's a little more subtle under the EU rules. It also includes control, and control of subsidiaries. Ownership is pretty much a straightforward 50% proprietary rights, but the control test under the EU regulations is really a lot more amorphous. Right to exercise powers to appoint or remove a majority of members of the administrative, management or supervisory body, having appointed solely as a result of the exercise of one's voting rights, a majority of the members, controlling alone, having the right to exercise a dominant influence, having the power to exercise, the right to exercise a dominant influence, and the right to use all or parts of the assets of a legal person or entity. And of course, when we were looking at these tests in relation to the Russian oligarch listing, we were very often looking at a rapid change of ownership, which of course we saw in previous rounds of Russian sanctions, and having to analyze new structures and taking a view. And of course, it's always very helpful, Dan was speaking about the regulators earlier, to have a good line to the regulators to be able to ask questions where that's possible. Certainly with SECO, it is possible to just call up and ask a question. EU regulators are accessible to a slightly less immediate extent. And of course, OFAC, you are going to have to wait until you get an answer to questions. But obviously, the extent to which the regulators can provide these clarifications is very helpful to us as a community trying to understand these sanctions. Now, we are looking here at the extent of reach of EU sanctions, and people were discussing this question of, actually, I think we were talking about extraterritorial reach. So when you think of secondary sanctions, US secondary sanctions, that is extending beyond the reach of the US jurisdiction, its airspace, its vessels, its nationals, its corporations, and its dollar, secondary sanctions apply regardless of the fact that there is no US nexus whatsoever. They can still bite. So we talk about sanctions that still have an effect, and of course that is why this sanctions regime is one of the most powerful and the most feared in the world. Now, by contrast, the EU reach is by declaration only. And I've actually highlighted for you here a document which really spells out the relative limitation of the EU jurisdiction. It covers the territory of the EU itself, so EU member states and nationals, aircraft, vessels, companies, entities incorporated under those laws, or business done in part or in whole within the EU. Note, actually, this is an EU document, and the EU itself says it will refrain from adopting legislative instruments having extraterritorial application. And interesting to see here that the EU has condemned the extraterritorial application of third countries' legislation, imposing restrictive measures. And of course, we saw some conflict on Iran over the question of extraterritorialism. Now, when we look at this Belarusian prohibition, the one that was set out in Regulation 765, this prohibition extended to three main planks. So first of all, the funds and economic resources belonging to, owned, held or controlled by the natural legal persons were frozen. So effectively that was the listing, that's the US equivalent of the specially designated national listing. Then there was also a prohibition on the making available of funds and economic resources, directly or indirectly, all for the benefit of those entities and bodies listed in Annex 1. And the participation, so this is the circumvention prohibition, participation, whether knowingly or intentionally, in activities, the object of which is to circumvent. Now, just thinking through exactly how this prohibition works. It is permitted to make a payment to a designated company or person under Annex 1, but only where those funds are going to be paid into a frozen account. So within the EU or to an EU bank that is going to freeze those funds. Now, what about performance? What about where you want to perform a contract, where you've prepaid the product and you just want to lift some product from an entity that is now owned by a Russian oligarch who's been listed by the EU and perhaps by the UK and Switzerland as well. Now, the better view is that a discretionary license will be required under Article 4A of that regulation. So don't make the mistake of thinking, oh, it's okay, I can lift because I've prepaid. Now, there is effectively a license, and the competent authority of member states may authorize, as appropriate, the release of certain frozen funds or economic resources. Now, just a few tips to make sure we are thinking, got our thinking caps on and thinking at a high level when we consider how to comply with these sorts of sanctions. Think about the trading terms you're using. Obviously, if you're trading, I appreciate this is more a shipping community, but FOB, delivery at the load port, let's say prior to imposition of sanctions, versus delivered. Then you have incomplete delivery into the EU, and you have product potentially going to be arrested and frozen at the border by customs in some of the examples we looked at. Remember that EU banks will freeze payments where there is actually a listed entity subject to the sanctions. And certainly the recent round against Belarus, there is an obligation on the banks to freeze. And remember that an EU-owned company, just because you're an EU company, just because you're based in the EU, you will then be subject to EU sanctions, even when otherwise you're operating entirely outside of the EU jurisdiction. So it's amazing the way these sanctions can sort of rear up and bite you. I also wanted to very briefly pick up on something that Dan has rightly been raising in the context of a shipping community concerned about sanctions, and that of course is the Venezuela risk of secondary sanctions. And what we are aware of is that, as Dan explained, this can be a particularly aggressive series of sanctions, and it's a very broad Executive Order 13850. So the Secretary of the Treasury, so OFAC, has authority in consultation with the Secretary of State to impose blocking sanctions on any person, including non-US persons, determined to operate in the gold or oil or in any other sector of the Venezuelan state. So this can include the energy sector, and we saw the Rosneft example being listed. Note, however, as owners, that there are certain products that are still permitted. These are not limited to soft. So for example, scrap metal, currently still permitted as long as it's not actually being sold by an SDN, that is to say an SDN listed government entity such as PDVSA. Our big tip for rejection to essentially put yourselves right as owners when you have made a legitimate nomination and your vessel is being rejected is to ensure you get a quick legal explanation to the charterer. We have seen an example of wrongful rejections of a nomination which was made on the basis that charterers incorrectly suggested that owners had previously lifted Venezuelan product. In fact, after analysis and explanation to the banks and insurers, it was found the product lifted by those owners from Venezuela was not in breach of any sanctions. Equally, you should take advice before accepting any charterers' orders that raise a red flag. And I think really training and taking advice when we are in the middle of a huge movement, and we are really coming out of Belarus, but I think we're going to be looking at a new round of sanctions for the Ukraine and Russia. Dan and I have put out a press release which will forward to you through the Shipping Professional Network after this meeting, just with a few tips and tricks on how to anticipate problems as we look at another potential round of sanctions, depending on activity at the Ukrainian-Russia border there. And just some tips also on avoiding adverse press. If we have, to take a classic situation where you have a counterparty world check report showing risky behavior in the context of a high risk listed sanctions regime, you've got a new deal involving a counterparty with a history involving fraud, which you can see when you do a world check or a world compliance, for example, or one of the other search engines, you can see what the press record is. So if you have someone with a track record of drug trafficking, bribe paying, bypassing of economic sanctions, you need to remember that reputational risk includes adverse press, adverse coverage, even though it's unrelated to the deal you're in, and of course, possible penalties. So with that, I think I have just done, this was really more just an example of how a sanctions regime can work. And I would just like to thank the Shipping Professional Network, particularly Claudia, Fabienne, and Gustav, for pulling this together for us. We are really delighted. We see some very familiar names. Hello to everyone, particularly in Switzerland, that we know, and would love to see you again soon. And with that, I think we should open up to questions from the floor.
Stunned silence. I think we've stupefied people.
I think people are actually potentially just wanting that drink that we normally share with the Zurich shipping network. And we had a lovely celebration with Gustav and the team earlier this year. But if there are any questions that you would like to put to us, feel free. I think most of you have our email. If not, SPNI will forward those on. And Dan and I will forward to you our briefing bulletin on the immediate impact of the Russia-Ukraine possible. Obviously, we're talking hypothetically, but if you read the press, it's pretty much headlines every day at the moment in the Financial Times and the trade newspapers, in Reuters, etc. So we'll send you out our tips, and it's an absolute delight to see you and to speak with you. It's obviously a lot easier in terms of time to do Zooms, but we look forward nonetheless to the next time we can clink glasses and meet you in person, perhaps around the Zurich or Geneva regions.
Yeah, thank you very much, Sarah and Daniel, for a very interesting talk. I think, so we ran a bit over time, so I think some of our participants have already left. So I guess in one way it's good there were no follow-up questions today, but I know from personal experience that Sarah and Daniel are very approachable and they work with these kind of things every day. So if the rest of you do come across smaller or bigger sanctions issues, or even just questions in case you want to look into doing some business that could touch upon this in the future, then I know that they are very much available for to answer your questions and to support you, and they do this all along. So very low barrier of entry in terms of contacting them. So yes, thank you very much to Holm and Fenwick, and thank you to Claudio and the SPNI for bringing us all together. I think that was super. And also great to see so many people from London, Mumbai, Hamburg, and Zurich come together. And you know, we hoped last year that things would normalize by Q1. Unfortunately, they have not, but I think they will normalize by Q2 now. So thank you.
Just to add, indeed, I think, Sarah, you timed it very well, speaking after Daniel. So he answered all the questions. So sorry, I gave your secret away. Hopefully Daniel didn't hear that. And just to also add thanks to everybody. Thanks to Sarah, Daniel, and also to Gustav as well, and Fabian, and the rest of you for attending and seeing you all. And any information that we'll get from Sarah and Daniel, those tips and so forth, then we will email it through to the attendees, so they also have it, as well as the link to the video once it's uploaded. Of course, there's, if you'd like to stay current, there's the social media, there's the Facebook, and then there's the Instagram also. And yeah, so look out for the next event in the second half of the year, and bid you good night or good morning wherever you are in the world.